How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question.
and I'm
How
gonna
did you
answer
find
your
out
question.
about it?
Mr. Copeland made statements that he admitted to killing Donovan Thomas. And don't take my notes. No.
Take Mr. Steele into custody, please.
No way, dude. You're watching a part of history right now.
Okay.
I believe that the court has put him in that position.
No, he purges himself of the contempt.
That's civil. He's not getting that civil.
That's civil contempt.
That's civil.
That's it. Respectfully, I would.
The Young Thug YSL RICO trial is spiraling out of control. Brian Steele points out evidence of coercion and witness intimidation by the judge and the state. The judge freaks out and asks how he found out about an ex parte conversation with the DA, a witness, and the judge. Steele refuses to answer, and then the judge sentences him to 20 days in jail over the weekend. The judge is straight up wrong here and didn't want to admit it. There's hundreds of defense lawyers citing case law, I'll show you at the end of this video, and over 25 defense lawyers came to Brian Steele's defense within hours of this happening on stream. Once again, I'm left speechless. I don't even know what to say. Just watch the full video. Hit subscribe. Here we go. First look at Thug on day 88. Got the clean knitted sweater on. Looking good. Looking good.
Mr. Copeland's had the opportunity to speak with his lawyer, and it is my understanding he's going to testify. That's the latest I can give you, okay?
Ah? What, he's testifying now? A weekend in jail with some bologna sandwiches changed his mind.
Sir, it is your intent to testify today. Is that correct?
Yes.
Okay. All right. Some of our jurors, please start name.
I wonder what changed his mind.
I got to say that.
He's already being difficult with the state.
Doctor.
Whoa, the state is getting a wireless microphone put in her hand now. Thank God.
Are you from Atlanta?
I'm from Canada.
Okay. Is that a section of the city in Atlanta?
I guess.
You guess. Did you grow up in Mechanicsville?
For sure.
You say for sure? All right. And what are your three brothers' names?
Overrule, sir.
Trey, Nato, boss.
Say that one more time. You said it fast.
Nato, Trey's boss.
Nato, Trez, and Boss.
I don't know. I went to a lot of different schools.
Okay. What are all the schools you went to?
I don't recall all of them.
When you went to high school, did you go to Southside?
Yeah.
And how old are your two children?
The same age.
Prior to any of this, do you have any criminal convictions?
Of course.
Okay. Do you know offhand how many?
Don't keep up with it.
There's a big stretch from Thug. Hit the like button for the stretch. It's intense in here today, dude. With Woody on the stand, it is very intense because of what happened on Friday.
Do you recall having a federal gun charge in 2015?
You asking me or you telling me?
I'm asking you.
What you asking me?
Did you plead guilty to a federal gun charge in 2015?
I think I did.
Did you get out of prison and then go to Wright Street?
Yeah, locked me up so much. I can't really.
And let me say this. When we say Wright Street, are you talking about the Fulton County Jail?
All right, I know the setting of this whole situation is not funny, but I can't help but chuckle when some of these guys, like the way they answer questions.
I got it feds in
2019. Okay. Ms. Coleman, do you have a nickname?
Yeah.
What's that?
Woody.
Do you know someone by the name of Shannon Stillwell?
What's his nickname?
SB. Or Shannon?
Come on, bro. He's in the courtroom. You know SB. You were friends with him.
Yeah.
Okay. How long have you known Shannon?
We went to school together.
And do you see Shannon in the courtroom today?
But I got a vision problem.
Okay.
I can't see that far.
All right. So
I got a vision problem. I can't see that far. Clearly a lie. I don't know why the state puts up witnesses they know are going to be difficult. It kind of makes them look bad.
if you want to stand up and look around the courtroom and look around the entire courtroom, tell me if you see Shannon in the courtroom today.
He's to the left, bro. This is amazing. The silent.
So you need to sit down.
Nah, I can right here. I ain't having any drink.
Okay, do you want some water?
You gonna give me a drink?
I'll get some water.
I don't drink water.
Well, I don't have nothing else for you. But I will put some water up there for you.
I don't drink water. Pretends to pass out.
Who am I looking for?
Shannon.
This is insane.
I think I see him.
Okay. When you say you think you see him, what do you think he's wearing?
Look like he wearing gray over there.
So who are you pointing to over there that's wearing gray?
I think the lady got red hair.
Okay, so you pointing to a lady and not Shannon?
The one behind her.
Okay, so you're saying you believe that the person behind the lady with the red hair is Shannon. Is that what you're saying today?
But it looked like her.
That's not Shannon Stillwell right here. So he's intentionally pointing out someone that isn't Shannon.
Does anybody else over there look like Shannon?
Yeah.
Okay, who's the other person who looks like Shannon over there?
He's standing behind the bald head dude right there.
He's standing or he's sitting?
Sitting down, I guess.
Okay.
Bro, it's funny because the bald head of the lawyers keeps being brought up every time they have to identify someone.
Bald head.
So you're saying Shannon's the one with the bald head? Or he's sitting
No, he's
behind
sitting
him?
behind the dude with the bald head. I think it's him.
Okay.
It's two people with dreads. I can't see. I just see dreads.
While y'all were in school, did y'all develop a friendship?
Nope.
Okay. At some point in time, did you ever develop a friendship with Shannon?
Yeah. At one point, we became cool.
Okay. And when you say cool, what do you mean?
COOL.
I didn't ask you to spell it, I asked you what you mean.
Well, we became cool. I don't know what you mean. I don't know. Oh, just a dude in the street.
You never met any of his family members?
I never met none of his family members.
Okay. What about any of his girlfriends?
What you mean?
Would the two of you go out?
I go out with anybody, even you.
I'm not asking about me. I'm asking about Shannon. Would the two of you go out?
We have went out.
Okay. How often have the two of you gone out?
I don't know. Well, I've been in jail most of that time, so
Did you all speak while you were in jail?
a few times.
So your friendship didn't stop just because you went to jail.
What you mean?
Did your friendship stop just because you went to jail? Or
Who determined when a friendship start and stop?
I guess you would.
I will.
Yeah. So did your friendship stop, or your coolness? Because you said coolness. Did your coolness stop with him when you went to jail?
I don't.
Okay.
Hey, Judge. I'm hot. Can I take this sweat off?
That 5-minute break turned into 25 minutes. Brian still has something to say.
Pursuant to the 6th and 14th Amendments of the United States Constitution and the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, he did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, supposedly in chambers of honorable court at times. District attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on.
Oh, that's not allowed, right? There can't be an ex parte conversation with the judge, state attorneys, and a witness. What?
But it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information and belief, that the lawyer for Mr. Copeland and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too, and the reason
Well,
is...
I'm asking you a question.
And I'm
How
gonna
did you
answer
find
your
out
question.
about it?
I'm going to answer you the question.
Okay.
The judge is shitting his pants. I think the judge realizes he's caught here with something he wasn't supposed to be doing. Wait, how did Steele find out about this? It has to be Mr. Melnick, Copeland's lawyer.
Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me.
But there was a witness there.
Those are ex parte for a lot of different other reasons, but certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not
How
going
did
to
you...
answer that question.
You're not?
No, I will not answer that
Why
question.
will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else...
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based on information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this... I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? If the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party.
A party?
Yes.
A witness who was sworn in Friday? The court's telling... This is what...
Yeah, that's what I was just saying. A sworn-in witness shouldn't be involved in an ex parte conversation.
What I was told. If this is not true, not true. This court
Mr. Steele,
handed Mr. Copeland...
Tell me how you
perjury.
got the information.
Listen, whatever you want to do...
Tell me
I'm
how
not
you
telling-
got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going
Well,
to say is this.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
That's-
this honorable court...
Okay.
Or excuse me, let me rephrase that. This court supposedly said I can...
He changed it from audible court to court. He took out the word audible. So this conversation could be why Kenneth Copeland is testifying now. Wow, insane. This is gonna be a mistrial. This shit's gonna be over, dude.
hold you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I
I'm doing
still
what
want to know,
everybody should do.
how did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why did
Sir,
this
I'm going to
happen?
hold you in contempt if you don't tell me who did.
I'm not-
Tell me who this
I
information
don't
is
want to
coming
be held
from.
in contempt.
Well,
I'm not
then,
answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am
tell
telling
you
you-
what. I'm going to give you 5 minutes. If you don't tell me
Don't
who
have
it is,
to. I'm
if
gonna
you don't tell me
continue.
who it is, I'm going to put you.
But let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you?
telling
How did you get that information
I go
supposedly
answer
from my
questions.
chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas, and don't take my notes. No.
The deputy tried to take his notes? This is literally a TV show. He said Copeland admitted to killing Donovan Thomas.
Okay, Mr. Steele, would you take the podium, please, sir?
The fucking judge's dog is barking behind him. If you didn't know, the judge has a dog behind him at all times for like PTSD, I believe from being in the army.
Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, as you know, Georgia rule professional conduct. Please check me. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
Bro, you can't hold a defense lawyer in contempt that takes the defendant's right away to have counsel, right?
I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. That's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte?
You're
acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this on court or any court to meet with me and a witness.
Adding the witness in there is the issue. That's the main issue the judge is ignoring. He's more focused on how it got told to Brian Steele than the main issue.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you.
You're
threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with.
To give you information, and you're saying it's not sum and substance, but I'm telling you, I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going to breach that confidence.
I don't want to hold you in contempt, but if this is that serious,
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, and listen, I'll do whatever you want. This is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we'll get.
Okay, well, then you'll be in custody until then.
There's no way he does this. There's no way he puts Brian Steele in custody.
You need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, shared that information with you, she probably violated privilege.
Well, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have
this information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information.
I'd like to know what information happened outside of presence. That's really it.
You can go into custody at this point.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence that you should not have been?
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay?
Why
that's for another day.
In the first place? I didn't know about this.
That's for another day.
So I raised it as soon as we found out about it.
Well,
this trial's over. Something's going to happen in the next 24 hours.
You should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele. That is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asking me to hold.
You're not supposed to have communication with a witness who's been sworn. You know, that, I'm not telling you, I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
The statement should be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
It
why
does.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
why aren't we entitled to the information?
you know, isn't
that the issue?
That needs to be told. But
We don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right under
Just
the Georgia
stop.
Constitution.
Just stop at this point in time, because
Article 1, Section
because
1, paragraph
you've already said that. You've already
the
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes.
No, I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms.
Okay. Excuse me.
Oh my God, Brian Steele is such a G. Why was a sworn witness talking to the state and the judge, and then now suddenly he wants to testify? Isn't that f***ing insane? I'm seeing so many defense lawyers on Twitter like freaking out over this.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt imposed upon a person for not obeying the court's directive. We believe illegally obtained
Mr. Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay. Yeah, he does. But
The court, now having found Mr. Steele in contempt, if the court continues in that position,
The legendary Keith Adams. Here we go, man.
that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court is engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. I am asking for a mistrial. I do not believe that we can proceed at this point based upon the information that we've received.
All right,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that.
On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost.
All the defense lawyers coming to Brian Steele's aid here.
8:30 for a 9 o'clock start. Did not start till approximately, I'm estimating 11 o'clock. We figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remain in the dark. I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days. But I will say, Your Honor, what I do know, just based on what we've heard over the last 20 minutes, it appears there was a meeting, knew nothing about, that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present. This was a critical stage in this trial. That error is a foundational, structural error in this case, and it is the cause for an immediate mistrial. I'm going to ask for the transcript, and I'm going to ask for the recordings as well.
I'm honestly speechless. I don't even know what to say. This trial is over. I don't know how it's going to go on after this.
I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information, and that's our stance, Your Honor. Thank
I
you.
have noted your motion for mistrial. It's denied.
It's denied immediately.
Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
No way.
Yeah, we're going to continue. I'm not calling nothing. You don't have that luxury at this point in time, sir. You don't. Really getting yourselves cross purposes at this point in time. Sir, I'm telling you. You are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time.
You're the one that had a meeting with the sworn witness and the DA.
I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. You're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning. But sir, I don't even know your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. Sir, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been.
Okay, well then you've made no, we're not doing that at this point in time. So you'll have a choice to make. Take Mr. Steele into custody, please.
Wow. No way, dude. You're watching a part of history right now.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of...
Okay, all right.
Oh my God.
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Oh my God. Steele is a G. I wonder if Thug realizes he paid for the best possible lawyer. This is a scripted TV show.
Continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But
There's no way that's gonna happen. There's no way.
Mr. Steele put himself in this particular position in terms of all these. I'm not asking for any other information privilege or any other conversations, but I need to know who told you.
That affords Mr. Williams the right during these proceedings while court is in session, both of his counsels, for Mr. Steele to be present in the courtroom. He can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session.
So Miss Love wants Mr. Steele back too. I think Miss Love is doing this because she's terrified of a mistrial.
Court's remedy does not affect his ability to have his counsel of choice. There was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom.
So she's saying there wasn't really anything said in this ex parte conversation. Apparently there's a transcript of it, but I mean, how can the defense just take their word for it? That's insane.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me. Certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But
we are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Let's get Mr. Steele out, please. You can tell him to put his tie back on.
Put his tie back on.
I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying that he was not going to go forward without having you present with him.
Order the transcript that we can see it and have a hearing with all witnesses.
No, I'm not going to order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. That's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. You're running a very thin professional responsibility. I don't think you have cover at this point in time. I think you're blowing your coverage at this point.
So are you, brother. Dude, I feel like they could get a transcript of the conversation within 20 or 30 minutes, have the lawyers look at it. If it's nothing, then it's nothing, and we move on.
But you're indicating what was said. I want to know who told it to you.
And I'm making it based on information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time. No. Yeah, I'm holding you in contempt because you won't tell me who.
How can something, I'm not trying to be obstruction, but how can something be attorney-client privilege for the court?
Well, because if somebody's a represented party and they disclose information that to you all as parties in this case, that could be a problem. That could be a problem. That doesn't make a difference, but you got information that you shouldn't have had. And then you turn around and say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of the trial.
It's not, well.
Oh, wait. Steele saying this conversation is now a material part of the trial, which makes Judge Glanville a witness, requiring him to be recused.
So witness testifying who met with the court and the DAs, that doesn't concern us?
Your Honor, may
Meaning the defense?
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will. You have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. If you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then I'll. In terms of what, sir?
I suppose contempt.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this.
Criminal contempt? I thought this was civil.
You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to this particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not.
So I'm seeing on Twitter right now that the judge apparently doesn't know the difference between criminal and civil contempt. Civil is intended to enforce compliance with a court order. A person alleged of being in civil contempt is often described as holding the keys to the jail. He just told Brian Steele that, but then said he's in criminal contempt. Criminal contempt is intended to preserve the power and vindicate the authority of the court, or in other words, punish those who violate court orders because there's no other remedy available. Judge Glanville doesn't understand that civil contempt has a remedy to coerce compliance with the court. Criminal contempt requires a punishment. Certainly appears he doesn't. So Judge Glanville is in the wrong here. Okay, we're just going to proceed with Copeland testifying.
I recognize myself.
Okay, do you recognize anybody else in 358?
Myself.
Do you recognize anyone else in?
Say faces covered up.
Okay, do you see someone's face who's not covered up in 358?
Yeah.
Okay, do you recognize who that person is?
I can hardly tell.
Okay, is that Shannon Jackson? Your Honor, at this point in time, I'm turning to impeachment.
So Schardt said she's showing him altered photographs.
Me, Shannon, DB.
So she's trying to impeach him by just showing relationship with him and SB, and he was acting oblivious, I guess.
But does that look like the three of you, DB and Shannon? Does it look like y'all?
I just said yeah.
Okay.
I can see, but I can't really see their face like that.
Okay.
I can't really tell who they are with me though.
Is that Shannon Jackson or Shannon Stillwell?
Now they do got a mustache.
Okay, so is this your testimony that that is not Shannon Jackson in this picture?
All I can say, I can recognize me with the hat on,
Okay, there's three people with hats on. Which person are you with the hat on?
with the writing on my shirt.
Okay. What does the writing say?
DRC, third YRC.
What does DRC mean?
DRC.
What does it stand for something?
You asked me what it means. DRC.
Okay, does DRC stand for something?
Not to my knowledge.
Okay. It does it stand for the robbing crew?
I'm not robbed.
Okay, that's fine. I'm asking you what does YRC stand for?
YRC.
Yes.
This stuff don't have no meaning. This how I got this shirt.
Oh my
That's your testimony
god.
today. That neither DRC or YRC mean anything.
That's how I got the shirt.
Okay. And then you said you recognize Shannon in this picture. Where's Shannon?
With the blue on.
With the blue hat on, the New York Yankees hat?
BB in the middle.
And is that Shannon to the right? Or to my right?
It looked like Shannon.
Did you talk to him about your secrets? Did you confide in him about life, things that had happened?
Now my seat go to the grave with me.
Okay. Of the Mickey Garlington.
Street name.
Little D.
For sure.
I'm sorry, say that again?
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury what do you mean by that?
I mean, he my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard of him. I know when DB died, this when I took him in.
Do you remember what year DB died?
I don't remember when DB died.
Okay. So was that every day? Was that once a week?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whole time.
Can I understand until you answer the question? I'm gonna have to ask you again. So was that every day? Was that weekly? Was that monthly? What was it?
I don't know.
Did you consider Little D like your brother? I know you call him your son, but did you consider him like a brother?
I consider him my son.
Do you recall ever telling any detectives previously that he's like a brother to you?
I probably did. Ain't no telling.
Okay.
These boys hanging out on the block with 30 deep shirts on.
That you sitting on the step in a white t-shirt and blue jeans and black and gray sneakers.
Yes.
Does that look like Little D?
I guess.
Well, someone you call your son, does it look like the person you know
I
to be
can't
your
see
son?
that. I just told you that from the beginning.
What, if anything, does what you're doing with your hands symbolize, if anything?
A bird, because I'm from Mechanicsville.
Is that the symbol for Mechanicsville?
We represent a bird. I wanted him to lie for me, and he wouldn't.
Okay.
When the police was accusing me for stuff, I went to Lil D and told him what I wanted him to tell the police, and he wouldn't tell the police that, so I got mad at him.
Okay.
Me and Shannon was friends, but me and Shannon was not together on the street as much as friends. We was not together a lot.
Okay.
It's been like 2 or 3 hours since Brian Steele was officially held in contempt, and now Judge Glanville's worst nightmares happen. An Avengers Endgame level of attorneys accumulated outside the courtroom, waiting to stand in solidarity with Brian Steele. I'm not joking. Apparently like 20 defense lawyers have pulled up to the courthouse to defend Brian Steele. Like known Atlanta defense lawyers, and apparently this lady right here is named ASHLEIGH Merchant, and she is one of them. Part of the Trump trial too or some shit, so let's go.
That you figured out somebody told me this information, and you somehow said that it's privilege, which I can't imagine. Or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. The lawyers are not allowed into your courtroom.
No, we just
Or they're not in your courtroom.
we just don't have any space, Mr. Steele. We can let in as many as we possibly can, and we'll fill up our benches at this point in time. We won't violate our security protocols. Do you have an attorney that's here for you, sir?
ASHLEIGH Merchant is here. She's the president.
Okay, all right. We'll let Ms. Merchant defend. Fine.
You know, Glanville's sweating hearing that name.
I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that. However, who told him that. He will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time.
Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, with criminal contempt, I told him what the contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said.
I think Ashley's about to school Judge Glanville on what civil versus criminal contempt is.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And
Oh, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is. A little different, Ms. Merchant. I won't disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding, and so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
that is one of the cases. Also, two other cases. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've got space allocations, as I told you.
2025 lawyers pulled up like the fucking Avengers.
There's room in the jury box, and then there's room in the courtroom, so we would ask that they be
I
allowed.
don't want them in my jury box, okay? No.
And at this moment, he f***ed up. The judge is realizing right now that there's case law.
The trial has continued. It has not stopped this trial. For you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. That's a real problem.
Mr. Steele has a right to make a motion like this. If there were ex parte,
He does.
But
I'm not saying anything, but he's kind of put himself in a particular position he's in.
No, Judge, I don't agree. I believe that
I'm gonna disagree with you, okay?
I believe that the court has put him in that position.
No, I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but
That's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in
so you
contempt.
can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also
But you've got the
summarily hold him in
information.
contempt.
But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. Eavesdrop, which I don't believe he did at all. I don't believe that for a minute. I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned
I
it.
think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information.
I'm just sitting here speechless. I can't even believe this is real. She's low-key schooled in this man.
I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness, necessarily. It cannot be an ex parte proceeding without you being
I saw that on Twitter earlier. This requires him to be recused if he's a witness.
a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case.
Judge f***ed up saying it's criminal contempt.
Those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge.
Oof. Oof.
And he has the right to subpoena witnesses, he has the right to an attorney, he has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. For it to be ex parte, you have to be a witness. It can't be both ways.
I'll let the appellate court decide that. Anything else?
No, we'll file a notice of appeal,
Okay,
and we need
well,
to have the order reduced in writing.
I'm going to do that right now.
And Judge, we would ask that you grant a bond at this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry. I think in
Just the case law on that is either
hold on.
More case law that shows he can give him a bond. I think the judge is scared of switching his ruling here. It sounds like he's scared of admitting he's wrong.
criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
His contempt is as long as he, when he tells me what the basis of the conversation was. I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
That's civil. He's not getting that civil.
That's civil contempt.
That's civil.
That's different. Respectfully, I would civil contempt impose punishment as a means of coercing future compliance with the prior order of the court.
Awkward as shit.
Prior order of the court, presumably, is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk.
That takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond. I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about this a second, okay? I'm gonna take 5 minutes out and we'll think about it.
He got schooled by Ashley, bro. All right, so this 5-minute break turned into over an hour. So the judge took an hour. Will he change his mind and admit he was wrong? Here we go.
All right, thank you for your patience, counsels. The court had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well. Then I stand next to your attorneys. I've made a clarification to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt for your failure to comply with my earlier order of today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m. subject to further order of this court.
An absolute travesty. What a coward. He couldn't admit he was wrong.
I'd ask that I can be with Mr. Williams and we work on our case all weekend. For all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
If that comes to pass, my support, I will talk with our sheriff and we may be able to make that.
No way. Steele just said he wants to be in the same cell as Thug. I hope Thug realizes he bought the best lawyer he could buy. Steele is saying, let me be with my defendant in the same celly, baby. Holy shit.
Okay. If that should occur, okay?
Funny tweet I just saw on Twitter. Dude got sentenced to 20 sleepovers with Young Thug. These two G's right here about to be cellies.
Your Honor, I have to prepare for my cross-examination of Kenneth Copeland over the next few evenings, and I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time, respectfully.
What?
Your Honor, respectfully, and if it's not released by the time that we cross-examine Mr. Copeland, our defense will be hindered.
Sir, that would be an issue you can certainly raise then and now, but because of the way it was the way it was disseminated.
Supposed admissions Mr. Copeland made about our case outside of presence, and based upon information and belief, the court handed Mr. Copeland allegedly the law on false swearing and perjury. And if that's true, I'd like to also talk with him, if he'll call, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information and belief.
And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients. We are certainly a party.
Okay.
And we were denied the right to be present.
All right, thank you, sir. I'm still going to deny it. All right, anything else?
What an absolute travesty. I'm going to go through some tweets here for you guys to understand a little bit better. So Andrew here is a really good lawyer. Let's go through some relevant law. First off, judges are not supposed to talk to parties without opposing counsel present, except in a few limited circumstances. Judges shall neither initiate nor consider ex parte communications by interested parties. I'm not aware of any rule that permits a judge to meet ex parte with a witness. And he cites a case right here. But talking with one party present, not notifying anyone else, and having a conversation with a potential witness about whether he would testify seems far beyond that. At minimum, Glanville can't hear the recusal motion. If a recusal motion is heard, then the sort of denials that Glanville has been making, in which he inquires instead about how the defense attorneys found out about the communication, can be an independent basis for recusal. Just keep citing cases, bro. As for whether Steele can be put in contempt for refusing to answer the judge's question, I'm dubious. While Steele argued that the communication was confidential under Rule 1.6, he was repeatedly interrupted by the judge and may not have been given a full opportunity to explain why he should not be held in contempt. contempt. Also, anything you learn through representation is confidential and you cannot be compelled to reveal it except through a court order. I am not sure that the judge simply telling Steele to tell him the source was proper court order. This was truly troubling, and I'm so glad that cameras caught the proceedings. In the most sympathetic possible reading, there was a threat to the witness and he wanted reassurance that he'd be safe, but defense counsel still gets to hear that. If a threat keeps a witness from testifying, state can claim defendant forfeited right to cross. This totally secret ex parte meeting is not like anything I've heard of before, and I couldn't find a case on point with it. Really strange. Ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues. The judge makes provision promptly to notify all their parties of the substance of the ex parte communication and gives the parties an opportunity to respond, which he did not do. And that's from Rule 2.9, assuring fair hearings and averting ex parte communications. Lester Tate's another lawyer. He tweeted, "I've repped lots of judges and folks accused of contempt. We'll be shocked if this is not reversed. It's indirect criminal contempt in which the judge is involved. Should have been referred to another judge for handling." Can't wait to read Judge Glanville's order. Does he now think this ex parte issue goes away? Because the lawyers are going to ask the witness about the conversation. That's where it's going to get interesting. On cross-examination, the lawyers are going to ask Kenneth Copeland about what was said and what he said, what the judge said. I honestly don't see how this trial continues. We have to start all this over and then it's just delayed more. This trial might be over, boys. Absolutely insane. Hit subscribe, comment down below, join the channel membership. Love you guys. Peace out.